rights implementation and monitoring systems. While the wins are more fun to discuss, it would be impossible to talk about sexual orientation rights without also acknowledging the significant walls that remain. In particular, my presentation talks about continuing widespread criminalization of same-sex conduct and the apparent hardening of opposition to recognition of same-sex rights throughout much of Africa, analyzing three factors which appear to be impeding the process and decriminalization efforts. Finally, the presentation closes with brief and early-stage thoughts on what legal barriers to equality mean for the limitations of a white-spaced approach. Toonen. Toonen was a 1994 case that was the very first international human rights case to recognize a human rights violation based on sexual orientation. In particular, the Human Rights Committee found in Toonen that Tasmania, and Tasmania is a small state in Australia, that Tasmania's anti-sodomy law, which criminalizes private, consensual sexual contact between adult men, although interestingly not adult women, is in violation of the right to privacy set forth in Article 17 of the International Covenant of Civil and Political Rights, a treaty that Australia is a party to. The Human Rights Committee also stated in Toonen, in dicta, so not in the holding, that discrimination based on sexual orientation violates both the right to equality and a non-discrimination set forth in Article 26 of the Covenant. While Toonen was an important decision for at least three reasons. One, it was the first time you had formal recognition from a United Nations human rights body that sexual orientation rights should be protected. Second, because it vindicated the important and foundational right that sexual minorities, too, should be able to enjoy sexual acts without fear of jail. And number three, because of its statement regarding discrimination based on sexual orientation being a violation of Article 26, right to equality and non-discrimination. It's important to understand, though, that in the wake of Toonen, it was not entirely clear what would happen with international human rights relating to sexual orientation, because Toonen was limited in at least three important ways. First, Toonen deals with the right to privacy, the right to be left alone if you remain invisible, right? So it's a much narrower right than the right to equality or non-discrimination. The actual holding in Toonen relates only to the right to privacy. Second, the holding in Toonen was narrow in the sense that the right to privacy under international human rights law is not absolute. In order to violate the right to privacy in Article 17, the state has to have an arbitrary interference with privacy in the home or with the family. In Toonen, this was a very fact-specific inquiry, and the court's decision that the Tasmanian law was arbitrary turned in part on the fact that Tasmania didn't enforce the law and the rest of Australia opposed the law. It was not at all clear that the same reasoning would apply in other countries where there was widespread support for anti-sodomy legislation. Last but not least, the Toonen decision was somewhat limited in the sense that the Human Rights Committee only has jurisdiction over countries that have ratified both the International Covenant on Civil and Political Rights and also the optional protocol giving the Human Rights Committee jurisdiction. So countries like the United States, who have signed and ratified the treaty but not agreed to the optional protocol, could never be brought before this committee. It's also important to note that the Human Rights Committee is an expert body. So we'll talk a little bit about UN structures because they're very important for the progress that's been made with regard to human rights as they apply to sexual minorities. But the Human Rights Committee is composed of 18 experts, so it's not representative of the position of the majority of governments that are participating in the United Nations. Nonetheless, Toonen is by far the most important international human rights decision relating to sexual orientation to this day. Let's talk a little bit about its treaty basis, because that's important for understanding the later cases and also the right to sexuality itself. So, as discussed, the United Nations is a complex set of varied institutions. It includes numerous different treaties, and each of those treaties, as well as some of the other institutions and bodies within the United Nations, have separate monitoring and implementation systems. Uniformly across the United Nations, there was widespread silence with regard to lesbian, gay, bisexual, and transgender people and issues prior to Toonen. Since Toonen, and to some degree leading up to Toonen, there was growing recognition of what's often referred to as the right to sexuality. The right to sexuality is defined as the right to express one's sexuality free from discrimination based on sexual orientation. So this right applies equally whether your sexual orientation is heterosexual or homosexual, although the violations obviously are more common for sexual minorities. It's important to understand when talking about the right to sexuality that lesbian, gay, and bisexual people claiming the right to sexuality are not seeking any additional or new human rights. And in fact, what's at issue when you talk about the right to sexuality are well-established core human right principles like equality and non-discrimination. And the only question is what equality and non-discrimination require vis-a-vis sexual minorities, right? The recognition of the right to sexuality faces two principal challenges. The first challenge is the fact that there is no mention whatsoever of sexual orientation in any United Nations human rights treaty. So they have to get around the lack of specific language. There is, of course, very broad language relating to equality and non-discrimination, but nothing specific to sexual orientation. Second, the second challenge for the right to sexuality is the fact that despite the fact that human rights claim to rest on the inherent dignity of the person, the human rights system itself and the treaties themselves are consent-based. Treaties are, in essence, contracts between states where they write down what they agree to be bound to, and the human rights system is really a system of soft power. It's a system where we name, blame, and shame, but we cannot coerce or require changes of the state. So what happens from a case perspective after Toonen? In both Young v. Australia in 2003 and X v. Columbia in 2007, one of the most important things really is the reaffirmation of Toonen, right? This wasn't just Australia and its sort of unusual situation where the country as a whole thought anti-sodomy laws were bad and this one state thought they were okay and how to deal with that. But in addition, you have an expansion of the rights, namely, in both Young and X, you dealt with a denial of pension benefits based on sexual orientation. In other words, these are both cases that were brought by people who were in a same-sex relationship who sought pension benefits that, had they been in an unmarried heterosexual relationship, would have been granted. But were not granted, were denied based on their sexual orientation. In both cases, the Human Rights Committee found that discrimination based on sexual orientation without reasonable basis is a violation of Article 26, again of the same treaty, the International Covenant of Civil and Political Rights, and in particular, Article 26, protection of equality and non-discrimination for all people. Significantly, this holding for equality and non-discrimination is much broader than the holding in Toonen. LGBT persons were entitled to more than simply to be left alone if they remained invisible. Under Young and under X, they can and should demand equal treatment without discrimination. In addition, Young and X are both broader in that they involve positive rights as opposed to negative rights. Again, the idea being that in Toonen, it was a question of being left alone. The issue in Young and X were both whether or not the couples were entitled to equal benefits, and the court found unequivocally that they were. The most exciting, so the number one, if I have a top 10 here. Top 10 human rights victories since Toonen, right? Because human rights work can get sort of depressing because you study a lot of the terrible things that people do to other people around the world, including in our own backyard. But so we have the first in the top 10 is the decision in Young and X, which expand Toonen, reaffirm Toonen, and expand Toonen both to equality, to non-discrimination, and to positive rights. The second, third, fourth, fifth, sixth, and seventh, and eighth human rights victories all relate to changes within the United Nations structure. And before we sort of dive into the weeds of what these changes are and why they're important, I just want to be clear that at the most basic level, at the time Toonen was decided, you had a United Nations human rights system that wholly ignored all lesbian, gay, bisexual, and transgender rights and people. They weren't included in any reports. They couldn't bring their issues for grievance. They really were just invisible in the entire human rights system, and this had been going on for more than 50 years. So these are important and gradual changes, and to me it was almost shocking when I went back and put dates to some of them, how recently these changes had occurred. But we know that, Toonen is in 1994. So after Toonen, one of the first ways that we see progress is with the periodic review process, okay? And the most important thing to take away from the change to the periodic review process is pressure, okay? Because basically every United Nations treaty, or at least the vast majority, have what's known as universal periodic review. And that means that every 4 to 6 years, depending on the treaty, every nation that's ratified the treaty is required to submit a report. And that report details how they are implementing the treaty, okay? After they submit the report, they're subject to public questioning on their record implementing the treaty. And the treaty monitoring body, in this case the Human Rights Committee, but it's different for each treaty, actually issues findings and recommendations for how they're doing and what they need to change and do differently in the future, which of course then the next time they're reviewed, did you change what we told you to change? Did you follow our recommendations? So prior to the Toonen decision, no part of the periodic review process included any discussion of lesbian, gay, bisexual, or transgender issues. After Toonen, the Human Rights Committee began asking for that information with every periodic report and cross-examining the countries about their record, ensuring the human rights of these individuals were being respected and that progress was being made in that regard. And they issued recommendations for things like decriminalizing same-sex conduct when that had not yet occurred in those countries. So the first of the UN progress or UN structure progress is periodic review. And again, the key there is really the pressure informally that is put on the states to make reforms. The second major change at the United Nations human rights level was with regard to special rapporteurs. So that's just a really cool, fancy word, but these are experts, and primarily they're experts on thematic issues. So, you're gonna have a special rapporteur for health, for example. But you can also have a special rapporteur for a geographic area. Okay, but these are basically experts who go and do investigation and issue reports in the areas that they've been charged to issue reports in by the Human Rights Council, okay? And believe it or not, in 2001, you get a Profile and Courage Award. The Special Rapporteur on Extrajudicial Summary and Arbitrary Executions has the audacity to include in her report a statement describing the extrajudicial killing of sexual minorities. You wouldn't think that would be that controversial. She's simply reporting facts. However, in response to this report she submitted, many states moved that the report provisions relating to the sexual minorities be stricken from the report before it was accepted, and that she be formally censured. So luckily, as sometimes happens when bad things occur, this actually spurred positive change. And numerous other special rapporteurs came forward and said that they too intended to include information on how the particular thematic area they were studying, the human rights violations relating to sexual minorities, were impacted. So, for example, there's a really strong special rapporteur for the right to health that talks about how the human rights violations against sexual minorities impact their health in negative ways and impede the realization of the right to health. But you saw that same thing across lots of different thematic categories. So to the extent the periodic review process change was about pressure, I would call the special rapporteur change about visibility, right? This is about acknowledging the human rights violations that were taking place and that were impacting sexual minorities. And to be clear, while the Human Rights Committee decisions, we don't yet have any breakthrough decisions on gender identity. They all relate to sexual orientation. When you started getting these United Nations human rights changes, all of these changes are going to relate both to sexual orientation and to gender identity. Okay, so they are broader in that sense. But with the special rapporteurs, you get visibility. With the Yogyakarta principles in 2005, now you get standards. So that's what's important about those principles. Now the principles, what they tried to do, it's not a formal UN document. Okay, but lots of experts at the United Nations were interested, and we talked earlier about the fact that it's not about new rights. It's about how do you take existing human rights law and apply it to sexual minorities? What are your obligations under existing human rights law as a state that's agreed to be bound by it to the sexual minorities? Well, the Yogyakarta principles define terms like sexual orientation, and they actually give state standards for how to comply with their human rights obligations vis-a-vis these groups. Okay, so if number one is about pressure, number two is about visibility, number three is about standards, the consultative status is really about a seat at the table. So the way the United Nations works, they have more than 1,000 non-governmental organizations that participate and give reports and speak and are part of the different human rights processes. Those non-governmental organizations have received what's called consultative status. Believe it or not, prior to 2006, each and every lesbian, gay, bisexual, or transgender non-governmental organization that sought consultative status was denied. Okay? And it is only in 2006 where we have a significant breakthrough and they finally get a seat at the table, which, as you might imagine, having a seat at the table and the ability to talk and inform the agenda actually spurs additional growth and concern for these issues. So the fifth change at the UN, and the sixth in my top 10 for those who are keeping track, is in 2009, when the Committee on the Economic, Social, and Cultural Rights issued General Comment Number 20. Now, general comments are not binding, and what they are is they are statements by the treaty bodies that monitor the implementation of the treaty regarding the proper interpretation of the treaty. Okay, so what General Comment 20 did was it told states, this is our opinion of your obligations under the Covenant on Economic, Social, and Cultural Rights with regard to sexual minorities. In particular, that you need to be sure that there's no discrimination and that they are receiving equal treatment before the law. This is significant because you'll recall that the Toonen decision and the X decision and the Young decision all related to a different treaty. They all related to the Covenant on Civil and Political Rights. In terms of the international structure for human rights, this is the other half of the puzzle. You had the civil and political rights already with those court decisions. These are the economic, cultural, and social rights. So if you think about things like education, employment, health, these sort of things are all within the rubric of the economic, social, and cultural rights. And so, as you might imagine, the recognition that there had to be efforts to stop discrimination in each of those areas was an important and landmark change. In 2011, you get the 6th United Nations change, and this one is perhaps even more indicative of how far we've come in the 2 decades since Toonen. So in 2011, and for that matter, again at the end of 2014, the United Nations Human Rights Council passed a resolution, okay? And that resolution called for the protection of human rights of lesbian, gay, bisexual, and transgender persons. So why is that so exciting? It seems relatively obvious. If you're going to be a human rights body, you ought to be concerned with that, right? At the very least, that ought to be part of your position. Well, unlike the other things that we've talked about, the first 5, that are narrow expert bodies, the Human Rights Council is a political body, which means that each and every state of the UN has an equal vote and a voice before the Human Rights Council. So this was the first time, and believe me, it had been proposed on multiple occasions. Back in 2003, Brazil brought, a very similar resolution and got absolutely nowhere. There were efforts by Germany to revise it. This particular resolution was co-sponsored by South Africa, Brazil, and 39 other countries. But it was a major political win and a statement that the recognition that human rights applied in important and significant ways to sexual minorities had suddenly gained a majority of support, as opposed to the support of a handful of experts doing important work. The report itself came out of the Office of the United Nations High Commissioner for Human Rights. And it was an investigation and study on discrimination and violence relating to sexual minorities. The report was updated again, and it was a broader and more expansive report, and the report closes with recommendations of what the United Nations as a whole is now saying. Not that there's not a lot of disagreement still, let's be clear. There is still a very large, significant minority that oppose any and all recognition that human rights should apply equally to sexual minorities. But suddenly, you have major movement and progress in this regard. So the report gives you the documentation and the recommendations. All right. So we've talked a lot about the wins, but of course, it's not all wins. We also have walls, and for the most part, because Toonen involved the decriminalization of same-sex conduct, and because it's such a fundamental threshold issue to be able to engage in that conduct, most of the rest of the presentation will talk in particular about decriminalization efforts. But before we do, I think it's important to at least acknowledge the work that still remains to be done globally. If you look at the report that came out, globally, the violence and discrimination against sexual minorities remains both widespread and prevalent, both in law and in practice. And in particular, the challenges that remain, it's significant not only to decriminalize. Obviously, the report recommends the decriminalization, that you repeal laws that prohibit same-sex conduct, but in addition that you enact and enforce anti-discrimination legislation relating in particular to housing, to work, to health, to employment, and that you better train your police officers, your court system, your investigators to investigate harassment, violence, and killing of sexual minorities. Okay? So important work to be done with that, and one thing that the UN report stresses less, but that certainly in other academic literature receives as much or more attention, is the idea of trying to combat stigma. We know that sexual minorities remain largely invisible and isolated. They have significantly higher rates of depression and suicide. And so culturally, we need to make changes that address that stigma. Okay, so when you look at the criminalization map, the countries in red are the countries that continue to have laws prohibiting same-sex conduct. And what do you notice? I mean, North America and South America are almost entirely gray, right? There's very, very little red. We have some outliers. We could talk about them, but I won't. But by and large, when you look at North and South America, when you look at Europe, when you look at Asia, outside South Asia, the progress over the last 20 plus years, to the extent there were criminalization laws, they're gone. We know that more than 30 countries have decriminalized same-sex conduct over the last 2 decades, right? So there's another one of your big top 10 wins. Very important legal development. Before I go too far, the 10th one that's a national litigation and law change issue is that we also have more than 30 countries that now recognize marriage or civil unions. 22 on the marriage, the remainder civil unions. But that also is a change wrought in the last 2 decades. But when you look at this map, it's pretty clear that the progress has not been uniform, and that in Africa and South Asia, the problems persist. The criminalization of same-sex conduct persists. And perhaps even more concerning, we actually are seeing an acceleration of a hardening of opposition to recognition of any kind of equality for sexual minorities. In particular, in Nigeria, you can get the death penalty for same-sex conduct. Uganda passed a law that would have life in prison for it. It was later repealed on procedural grounds, but Uganda remains on my list both for the murder of David Kato and for the other court decision that found that distributing condoms to homosexual men constituted promoting homosexuality in a jail sentence. So they're still on my target list. Also on the short list of sort of problems in Africa, you would want to include places like Tanzania, which also has a bad habit of murdering gay rights activists, and Gambia, who has changed their penal code in the last few years for aggravated homosexuality to equal a life in jail sentence. We've talked about South Africa's leadership, at least briefly. I would never want to be accused of treating Africa as a country. It is not. It is a continent. There is a reason that there is a statistic up there. 38 of the African countries continue to criminalize same-sex conduct, but that leaves many, many who do not. And even within those that do, there's obviously a great variety, both within the country and between the countries with regard to those rights. With regard to those laws. But I think when you look at the lack of progress and perhaps the backsliding in Africa, you have to ask why. What are the factors that are impeding decriminalization? And I will suggest at least 3. The first is colonialization. It leaves a terrible legacy. First of all, it's colonialization that brought the anti-sodomy laws. They're usually unnatural acts is the magic word in most of the laws in Africa still. But the colonialization leaves lots of bad legacies, the laws themselves, a strong nationalism and a distrust of the West and Western values as corrupt, and making it very difficult to influence the countries. In addition, you have issues of neocolonialism with regard to, in particular, aid conditionalism. We have a lot of countries, the UK is one of them, that have actually tried to tie the aid they give to different African countries to their progress vis-a-vis sexual minorities. While that's certainly a well-intended plan, it has led to a lot of backlash in Africa where the countries understandably resent that the West continues to try to control them indirectly, having surrendered direct control. And they also, unfortunately, blame the sexual minorities for costing them money. Also under the category of neocolonialism, you get the efforts to fight HIV that have relied in large part on faith-based organizations, many of whom oppose homosexuality and have been vocal and active in fomenting homophobia and the passage of these stricter criminalization laws. Last but not least, you have media and politics. Because it's popular to hate the West, and because there is the myth in Africa that homosexuality is a Western plague and it is a Western value, the media routinely plays into that because it helps sell papers. The politicians routinely play into it because it helps garner votes. So this is what the human rights community is up against in terms of challenges in Africa. So the question becomes, at least in part, is a rights-based system up to the task? What are its abilities and its limitations? Well, we know that, and this is my last slide, we know that despite the language and lofty ideals, vindicating human rights almost always requires consent. Political will to change, they have to want to do it, and at least in present, in Africa, in parts of Africa, that is lacking. Yet, the human rights structure, while certainly imperfect, does appear to provide a benefit even in this situation. Because while we cannot, and perhaps should not, force other countries to change their laws on criminalization without popular support, we can still utilize the human rights structures to engage in respectful dialogue, to try to build consensus where we can, and to develop leadership. Together, these 3 options are probably the best hope for a breakthrough in the wall of criminalization without backlash. Thank you.